Good morning. Well, thank you for giving up your morning and for joining me and Will in detention. I don't know what you're all being punished for, but it must have been bad if you're spending your morning with us. Now, detention is a hot topic, at least by the standards of the insurance, it's a hot topic. And there are a couple of reasons for that. Firstly, there have been a spate of recent cases arising out of detention. And I put a couple of examples up there. The Be Atlantic was a Supreme Court case involving a ship that was implicated in drug smuggling in Venezuela. And there was a long trial involving Venezuelan expert evidence, and then it ended up in the Supreme Court on issues involving causation and the scope of cover. And then the magnificent case, the Zuzu, which I was involved in, another Venezuelan case. This time, the allegation was that the ship had been trying to smuggle diesel oil out of Venezuela, even though the ship was actually only going up and down the Venezuelan coast. And that went to a commercial court trial last year, and a terrific victory for the insurers. And in both cases, the vessel was detained on the basis that it had been used as an instrument of the alleged crime. And there were long detentions in both cases, which were said to amount to total loss of the ship. So the first sort of reason why this is very germane at the moment is because of what's been decided already. But the second reason is because of what's coming up in the pipeline. And there are two really enormous sets of disputes at the moment. One of them is relates to vessels detained in Ukraine. And the 1 year anniversary of the war in Ukraine has just passed. So these cases are going to start coming through the pipeline imminently. And we'll see the importance of the 1 year date in a minute. And then we've got the mother of all claims, in the commercial court at the moment to do with Russian aircraft or foreign aircraft which are in Russia. And that seems to involve pretty much every insurance lawyer in London, as far as I can tell, said to be the largest loss since 9/11 in the London market, apparently. And there's a CMC in that next week, which is going to involve Tom and all the counsel in the world, as far as I can tell. So it's a really hot topic. And so well done for coming. You correctly identified that this is an important thing to learn about. And the questions that we need to consider in a detention case are up there on the screen, and there's 4 of them. Firstly, is there a loss? Secondly, is it covered? And if so, who's it covered by? Thirdly, what interest is insured? And fourthly, the most important question, which barrister should I instruct? And Will and I are going to divide those questions up and deal with them in turn. So the first question is always, is there a loss? And starting with the basics, the 1906 Act categorizes all losses as either partial or total. Most losses by detention are total losses, but they can be partial losses. For example, if a vessel is detained for a long period, she can suffer damage to her hull or to her equipment as a result of the detention. But usually we're thinking about total losses in the detention context. And the Act recognizes 2 types of total loss, an actual total loss, or an ATL, and a constructive total loss, or CTL. And one important point to recognize at the beginning is that the concept of a CTL is only relevant or only applicable in marine insurance. So a sort of threshold question when you're thinking about CTL is whether you're dealing with marine insurance at all. And marine insurance is defined in a sort of slightly circular way in the Act to mean losses incident to marine adventure. But you do get some sort of problem areas. So I was involved in a case where cargo was insured under a goods in transit policy, which had a storage element stuck on the side. And the goods were lost during the storage component. And one of the questions was whether the concept of a CTL was applicable to the storage aspect, storage ashore. And the answer is, like everything in commercial law, it's always a question of construction of policy in the end. But anyway, so something to watch out for is that CTL is a marine insurance law concept. Now, detention claims are usually pleaded as an actual total loss, or alternatively, a constructive total loss. But an actual total loss is pretty rare. It's very difficult to establish in practice. And the reason is that for an ATL, the assured must be permanently and irretrievably deprived of its property. So it's a high threshold. And the point is illustrated by the Bunga Malati Dua, a piracy case, where the ship was seized by pirates and the assured claimed for an actual total loss. And the court said there was no ATL because there was always a possibility of recovery. And an important factor was that the pirates were demanding a ransom, albeit a very high ransom, and one that was unlikely to be paid. But as long as there is any hope of recovery, there's no ATL. So the fact of the ransom demand means that you're in a sort of negotiating situation where the vessel might come back. So that's why it's like Dante's Inferno, and you have to abandon hope altogether if you want an ATL. And what that means is, in practice, usually we are interested in constructive total loss. And CTL is usually concerned with this sort of situation where repair costs exceed the residual value of the insured property. So it's like when Will writes off his Jaguar, it's that sort of familiar concept. But in detention cases, it has a special meaning, as we'll see. So there's a special type of CTL which only applies in detention cases. And the effect of a CTL is to put the assured to an election. The assured can either treat the loss as a partial loss or abandon the subject matter to the insurer and treat the loss as a total loss. So that election means that the requirement for the election means that a notice of abandonment is an essential feature of CTL. So there's always a requirement for a CTL. If you have a CTL, there's always a requirement for a notice of abandonment, except where one of the limited exceptions applies, and they're quite rare. So usually, when we're thinking about CTL, we're thinking about notice of abandonment as well. And as I said, in detention cases, CTL has a sort of specialized meaning under the Marine Insurance Act. So the Act provides that there's a CTL where the assured is deprived of the possession of his ship or goods by a peril insured against, and it's unlikely that he can recover the ship or the goods. And there are a couple of points to unpack in that definition. So firstly, deprived of possession is a term of art. It doesn't mean possession in the ordinary sense. Possession here means free use and disposal. So the owner can be in possession of his ship or her ship, but still fall within the section and still establish a CTL if in reality they don't have free use and disposal of the ship. And a good example of that is the Zuzu, where the ship was detained by the Venezuelan secret police, and the crew were on board the ship at all times under sort of house arrest or ship arrest. But the crew were there, and through the crew, the owners were still in possession, but the ship was unable to sail. So that was enough to count as a CTL in theory. So the first point is possession has a sort of special meaning here. The second point is that unlikely that he can recover the ship or goods means unlikely that he can recover the ship or goods within a reasonable time. So there's an implied reasonable time qualification established by the Bamburi, which I put there. So if you know that you're going to get your ship back at some point, maybe in 10 years' time, you can have a CTL, but you can't have an ATL. And that's one of the important differences. So likelihood of recovery in a reasonable time. And that means that the key question in CTL cases, we're trying to establish a CTL is it likely that we will get the insured property back within a reasonable time? And a really important question, therefore, is when you answer that question. When do you answer the question of whether it's likely that you'll get your property back within a reasonable period? And obviously, one's perception of what is likely to happen in the future changes over time. In some older cases, it was argued that once there was a CTL, subsequent events were completely irrelevant. And there was even a particularly ambitious old claim where a ship was captured by the Portuguese and then a few weeks later was restored by British Navy. And the news took so long to reach the ashore in London that he learned of the capture and the recapture at the same time. And he still presented a claim for a CTL to his insurers. Now, unsurprisingly, the court said that's not the right approach. You have to consider two relevant dates: the date of the notice of abandonment and the date of the issue of the claim form. So that the ship has to be a CTL on both of those dates. Otherwise, you can't claim for a CTL. So that's the law. In practice, the London market's found a way around that. And what invariably happens in practice is that the assured and the underwriters enter into an agreement when the notice of abandonment is tendered, that they will treat the notice of abandonment as though it were the date of the issue of the claim form. So basically, the parties agree that there's only going to be one relevant date, and it's the date of the NOA. That's known as the writ clause. And the reason for it is that if you didn't have that agreement, then a sensible assured would always issue a claim form straight away as soon as they tender the notice of abandonment, which obviously underwriters don't want. So it's in everybody's interest to agree these writ clauses. And what it means is, if effectively in practice, you're assessing likelihood of recovery on the date of the notice of abandonment. And it's a prospective assessment. So you stand where you are on the date of the notice, and you look forward and you say, am I now on this date likely to get my ship back within a reasonable time? And a sort of peculiar feature of it is that when the court comes to assess likelihood on the date of the NOA, inevitably the court will have had the benefit of subsequent events. So the court will almost always know whether in fact you did get your ship back or not. And the court is willing to look at subsequent events. It says, okay, that is admissible as showing the true likelihood as at the date of the NOA. So if in fact the vessel is restored a week after the notice of abandonment is tendered, you might have a difficult job persuading the court that it was prospectively unlikely to be recovered within a reasonable time on that date. It doesn't stop people trying that argument. And again, in the Zuzu, that was one of the sort of peculiar features of the claim, is that the notice of abandonment was tendered, and then about a week later, the vessel was returned to the owners. But the owner said, even then, on the date when we tendered the notice of abandonment, this wasn't foreseeable. It wasn't reasonably likely. Still likely to be retained for an unreasonable period. So we also need to consider what a reasonable time means. And I mean, that is pretty much how long is a piece of string. Obviously, there's no hard and fast rules. It's a question of fact. I think there's one case which uses 12 months as or if they accept 12 months as being a reasonable time on the facts of the particular case. And I think because of that, as a result of that decision, it's very common to see a detainment clause in policies. I think there's a detainment clause in the institute clauses. And it provides that if the vessel is detained for more than 12 months, the assured is deemed to have been deprived of possession without any likelihood of recovery. So it basically says you just start the clock at the moment of the first detention, and then you keep counting. And as soon as you get to 12 months, that's a CTL, a deemed CTL. And that avoids some of these difficult questions. But even where you have a detainment clause, it's still open to the assured to plead and prove CTL at common law. So often one sees pleaded reliance on the detainment clause and reliance on a CTL at common law under the Act in the alternative. So it sort of potentially avoids these issues, but we, as lawyers, we still have to deal with it. And then, yeah, the assured has the choice of relying on one or the other. And an important feature of these detainment clauses is that in order to rely on the clause, you have to show continuous detention caused by an insured peril. So you have to have not just 12 months of detention, but 12 months of detention continuously caused by something which is insured. And Will's going to talk about the scope of the cover for detention in a minute. But you have to be, as a result of that, you have to be aware of detention, which starts out as a particular type of detention and then changes in character over time. And one of the arguments that has been run in a couple of cases is that detentions which start out as being covered, for example, because, as not being covered, as being excluded, for example, because they are lawful under local law, then change in nature over time and become unlawful or politically motivated at a certain point. And the answer is that you have to show 12 months of detention, which is caused by an insured peril, in order to rely on the clause. So Will's going to come back a bit to talk about whether unlawful is enough and what is required to take detention outside the scope of the ordinary cover. So a couple of other points. But firstly, the loss doesn't have to have become a total loss within the policy period. So if the vessel's detained during the policy period, but the recovery becomes unlikely after the policy expires, that's still a CTL which is capable of being covered. And there's also no requirement that the vessel has actually been abandoned by the assured. So it's enough if that statutory test is satisfied and that recovery is unlikely within a reasonable period, even if in fact, subjectively, the assured is still hoping that the vessel will be restored to it. And then finally on this, there's a sort of old principle of redemption of loss. And it happens surprisingly often that a vessel is recovered after having been alleged to be a CTL. And the position is that if the vessel is recovered before the action is brought, or if there's a writ clause before NOA is tendered, then the losses are deemed and you can't claim for a CTL. But if the vessel is recovered after the claim is issued or the NOA is tendered where there's a writ clause, it is still possible to have a CTL, even if the vessel has been restored back to the assured. But in that situation, you have to consider the underwriter's rights of salvage. So on payment of a claim, the underwriters would have the right to take over the vessel. But that happens surprisingly often because assureds would prefer to have the insurance proceeds than the vessel. So quite often you see cases where the vessel's been restored after having been CCL, but you still get insurance claims. Now I'm going to hand over to Will to talk about coverage.
Good morning. Welcome to part 2 of this talk. And I'm going to look at if there is a loss, is it covered and by whom? So really what we're talking about is where if you have a detention, is it covered by typical marine insurance wording? Or is it, if not, is it covered by typical war risks add-on insurance policies? And as part of that inquiry into the war risk insurance, I'm going to look at the exceptions to war risk cover. Then I'm going to just touch on the situation in Ukraine, how that might play into this area. And finally, I'm going to look at a few procedural points around the notices of abandonment. But before we start on this inquiry, just a note of caution from Arnold, who says that the ascertainment of liability for a particular type of loss might be an exercise of formidable difficulty in this area. And because of that reason, I want to start by looking historically at how cover was provided or accepted, and then how we've arrived at the modern institute clauses. So historically and under the Marine Insurance Act, captures, seizures, restraints and detainments are defined as maritime perils. That's under section 32C of the 1906 Act. And following that, the scheduled ship and goods policy or SG policy wording to the 1906 Act included cover for those perils. So the starting point is that if you had a detainment, it was covered under that wording. But then, by reason of the rule of construction in the 1906 Act, that's rule of construction 10, the term arrests or detainments or restraints was defined to refer to political or executive acts and not to include a loss caused by riot or ordinary judicial process. So there was already a narrowing of the type of detentions which would be covered under the standard SG policy wording. what happened alongside that, as that wording came into usage, is that the insurance market would then add what was called an FC&S clause, or a clause by which the insured warranted the vessel was free of capture or seizure, in order to exclude effectively those war perils from the scope of cover. The reason why that's worth mentioning is because if you're looking back at older authorities, you'll need to understand how these particular insurance wordings fitted together to see what was happening in the analysis. So in tandem with that standard marine insurance wording with the FC&S exclusion clause, the insured would then add on to that war risk insurance cover, which would cover loss which would have been covered had it not been excluded by the FC&S exclusion. And if you're finding that a bit tortuous, then it is. What it leads to is a complex, multifaceted inquiry, where firstly one would have to consider, was the loss caused by a covered marine peril? Secondly, if it was, is it excluded by the FC&S clause? And then if it is it covered by the add-on war risk insurance? So because that was all rather complicated, the modern institute clauses were introduced in 1983 in an effort to clarify the position and make it clearer to the insured in which cases war risk perils would be covered. And I've included in your handouts actually the two examples of standard institute clauses. And just for today's purposes, I've picked whole cover, but you can find similar matching clauses through most of the different types of cover, if it's P&I or cargo. So on page 27, you'll find the clause 23 of the standard institute clauses for hull time clauses. And that is your typical war exclusion wording. It's worth just having a glance at that because we'll come back to talk about it in a minute. But effectively, in clause 23.2, it excludes those perils that originally would have been excluded by the FC&S clause. In other words, capture, seizure, arrest, restraint, or detainment. And then, interestingly, in brackets, barratry and piracy excluded. So you've already got exclusions from the exclusion and the consequences thereof. So that's the cutout from your standard marine insurance. And then if you turn a few pages forward, you'll see the Institute War and Strikes clauses. And clause 1 of that standard wording then providing cover at 1.2 for those perils that were excluded in the main policy under the war exclusion. So capture, seizure, arrest, restraint, or detainment, and the consequences thereof. What you need to remember, and what we're going to be covering also in a minute, are that there are exclusions from the war risk cover, which are at clause 4, and in particular at clause 4.1.5, an exclusion for detentions that arise by reason of quarantine regulations or infringement of any custom or trading regulations. And then at clause 4.1.6, the exclusion for detentions which arise by reason of ordinary judicial process or failure to pay a fine or other financial cause. So, as I said, you find a similar matching for other policy areas, and the result is a typical agglomeration of policies whereby a loss by detention will not typically be covered under marine insurance policies, but sometimes it is. And secondly, a loss by detention might be covered under war risk add-on, but not always. So we're going to go back to look at each of those questions and see in what circumstances you might have a covered detention under your war risk clause. And then secondly, if there are any circumstances where you might have a covered detention under your standard marine policy wording. And first of all, as an important precursor to that inquiry is to understand what is meant by detainment or detention. So it means something which is not ordinary judicial process, as we've seen. So in other words, an executive act of a person in power or somebody purporting to have official authority. But there's no principal distinction between the three terms arrest, restraint, and detainment. What we're talking about, as Ben has touched on, is a deprivation of possession with the meaning that Ben outlined. And certainly the use of force or imminently anticipated force will suffice. to give rise to a detainment. But what about if the voyage that you're on becomes illegal at common law whilst you are partway through it, or before you are due to commence the voyage? Well, that may amount to a detainment. That comes from a case called Sunday and British and Foreign Marine Insurance in 1916, when two vessels were en route from Argentina to Germany. War broke out, and then there were then proclamations of the king making it unlawful to continue to discharge the cargo to Germany. And the Navy directed the vessels to proceed to British ports, which they then did. And the cargo owners warehoused their goods in the UK. Well, there was no actual restraint because there had been no exertion of force. And it was submitted on behalf of insurers that there was therefore no restraint, so no covered detention. Interestingly, insurers accepted that if they were wrong about that, the result of the analysis would be the same whether the declaration had come from Germany or England, or whether war had broken out without any declaration, which I think has some interesting echoes with the current situation in Ukraine. The House of Lords held that there was no doubt that the declaration was an act of the state, and it didn't matter that it didn't directly restrain the vessel. Earl Lawburn said that force is in reserve behind every state command, and so the loss did arise by reason of restraint. Lord Atkinson said that the operation of the common law could not in this case be separated from the act of the sovereign, so that it was something which arose not by reason of ordinary judicial process. That case hasn't been cited as far as I can see since 1962, but I think it does raise an important principle when considering the current situation in Russia and Ukraine. And I just want to touch on that next. So this slide shows you two maps of the Black Sea and also the Sea of Azov. And the red circle is then zoomed in on the right-hand side. And you can see that the Sea of Azov, the exit from that sea is in the bottom middle of that picture through something called the Kerch Strait. And Russia at the moment controls access to the Kerch Strait. And a complex legal position arises there because it depends whether the passage is to be regarded as an international strait. Obviously, the majority of the international community would regard that it is, because the coastline to the west is Crimea and to the east is Russia, whereas Russia disagrees with that and says that because the coastlines on both east and west are both Russia, what you're talking about is an internal passage through that strait. And against that background came the declaration of the Russian State Agency for Maritime and River Transport on the 24th of February 2022, so at the beginning of the war, that movement of commercial vessels in the Azov Sea was suspended until further notice. As far as I can see, that notice appears to have been given by Rosmerikflot, which is a federal executive body of the Russian state. Therefore, arguably its acts may constitute acts of the state. So that's the Azov Sea. And then in the Black Sea, what we can see here is an east-west line that goes from the most southerly tip of Ukrainian territory on the west coast of the Black Sea across to Crimea. And Russia has positioned naval vessels in that, across that line since the beginning of the war, which arguably amounts to a detainment of vessels that are stuck to the north of that line when viewed in conjunction with the notice to mariners preventing navigation in that area. So it appears quite likely to be a detention. And the point of dispute that may arise is what is the impact of the Black Sea Grain Initiative on vessels that are stuck in this area? It has been possible in some cases for vessels to leave by discharging cargo and then carrying a cargo of grain. And the question is whether to act as a prudent uninsured, you should be taking that step, or whether you don't need to do that. So that's about arrest, restraint, and detention. Capture and seizure were the other perils in the clause. And they're likely to refer to forcible possession by use of a lawful authority or overpowering force, but I'm not going to cover those in detail today. So what I want to turn to look at are the exclusions under the war risk policy. And the first one is where the detention arises by ordinary judicial process, although arguably that's just the proper construction of the peril in the first place. And we've seen one example where a declaration of war was held to result in a detainment. The first important point is what we're talking about is civil proceedings. So criminal or public proceedings are not excluded because they don't count as being ordinary judicial process. So where this issue typically arises is where you have on the face of it civil proceedings, but then the insured will argue that what you're really looking at is an executive act. And there are three cases that I'm going to mention briefly. First one is the UNITA from 1971. There, the insurance was on their old style ship and goods policy that we spoke about at the beginning, with the FC&S clause deleted and war risk clause added. So it did provide cover for war perils. Mr. Justice McCarter said that the regime was tortuous and complex in the extreme, and he implored underwriters to devise more straightforward and easily comprehended terms of cover. He then considered the fact that Vietnamese customs officials found smuggled goods on board the vessel, detained the vessel, and it was later confiscated by order of a special extraordinary military tribunal following conviction of some of the crew. And he said that the original detention was a political act because it was carried out by state officials, and further that because the members of the special court were appointed by generals and did not have legal training, that had no jurisdiction to order confiscation of the vessel, and what occurred was therefore outside of ordinary judicial process. And that finally, in any event, the interposition of the confiscation by the court following the officials seizing the vessel didn't prevent the original cause being one of executive acts. But the insurers succeeded on appeal in that case. The Court of Appeal did not agree that the special court had acted ultra vires, and detainment, they said, was caused by the infringement of the customs regime. And Lord Justice Fenton Atkinson said that the special court, to be something which wasn't ordinary judicial process, you'd have to show the court was not acting bona fide as an independent judicial body, but rather as a puppet court following the directions of the government or knowingly exceeding its powers. So a very high benchmark to be able to, for an insurer to be able to show that. There is an example of that threshold being met in the Silver case from 2011. In that case, the vessel was arrested by the Port Suez court in respect of a judgment debt that was owed by entirely unconnected parties. In the context that Egyptian law would have required an arguable case that the vessel was an asset of the judgment debtor, and there was no arguable case. The court there referred back to Lord Justice Fenton Atkinson in the UNITA and said that no reasonable court could have acted as the Port Suez court did, and that they were exercising their own power for their own purposes, not acting bona fide. And effectively, what had happened was an extortion by the state under the veneer of court process. So in rare facts, you may be able to meet that threshold. Ben's case, the Zuzu, is a good example of how difficult it is to show that a civil judicial procedure has become a covered detainment. In that case, the insured argued that the vessel had become unlawfully detained after a period of detention. And the court recalled that even if there'd been a bona fide error by the court, that would not be enough for something to be not caused by ordinary judicial process. Okay, so we've looked at that exclusion, and I just want to move on to touch on the other exclusions from war risk cover detentions. The first one is infringement of customs regulations. In the UNITA, the insured tried to argue that detainment was a confiscation due to smuggling, which was not infringing a customs regulation, which would mean something which was imposing a duty, something of that ilk, rather than simply a prohibition on imports. That argument was dismissed by the trial judge and given even less consideration by Lord Denning in the Court of Appeal. So there's really no doubt that that exclusion will extend to circumstances where import is prohibited and not just regulated. Bravely, the insured in the Clea Vodos of Rhodes in 2003 gave this another go, but again failed again, and the judge affirmed really that the infringement of customs regulations will include smuggling. The scope of the exclusion was also considered by the Supreme Court in the B Atlantic, because in that case, owners submitted that the exclusion for detainment by reason of infringement of customs regulations had no application where the insured peril relied on was a person acting maliciously, which is one of the other covered war perils. So they says we're not relying on there being a detention to give rise to coverage. What we're saying is that this arose because of malicious acts. Lord Mance said that in fact the owners relied on there being a constructive total loss by reason of the detainment clause, which was exactly the subject matter of the exclusion, and therefore the circumstances were, at least in principle, capable of being excluded if they are caused by infringement of a customs regulation. And so it seems likely that whenever a constructive total loss is established by detainment, then this exclusion is potentially engaged. So, for example, it would also potentially be engaged if the detainment is caused by any of the other insured perils. But of course, if you can show that the detention by, even if ostensibly by reason of infringement of customs regulations, in fact stemmed from improper exercise of judicial or political power, then the exclusion will likely not apply. Just pausing there, it's worth noting that what we've been looking at here is exclusions from war risk cover. What may result from that is that there are gaps in cover for the insured, because you may have a cover which is excluded under the war risk cover exclusion clause in the main insurance policy wording, and is then also excluded under the war risk cover because it falls into the exclusion clause. It doesn't necessarily map back to something which is covered under the original policy. And Lord Mance was happy to accept that that would be the result of his reasoning in the Atlantic, that there just may be gaps that arise. So two further points. Firstly, in relation to quarantine and trading regulations, there's been no judicial consideration as yet of when a detention might have arisen under quarantine regulations, but the same principles are likely to apply. So in other words, you would need to consider whether the real cause was the improper exercise of executive power, and also that that exception is likely to apply potentially whichever peril is relied on, even if it's one of the others like a malicious act. In relation to trading regulations, the court considered the meaning of this in the Elisa Glacial in 2002, where a vessel was detained on grounds of illegal fishing. So the regulation was about the prohibition of fishing in that particular area. There was obviously an impact on the trading of the vessel because they were going to fish there and then bring back the fish and sell. But the court remarked that this exception had been introduced in the aftermath of the Iran-Iraq war and the effect of the sanctions regime in place at the time, that what one had to do was look at the nature and purpose of the regulation and not how it might affect a particular vessel. And that what would be covered under this exclusion is where the trading regulation relates to the sale or importation of goods and not to other matters.
Just say, well, Elisa is a good example of a case where there was an argument that the nature of the detention changed over time.
Okay.
Because it was initially the question was whether it was a trading regulation or not, but then the owners failed to put up security, I think, that the vessel released, and the suggestion was that from that point on it was excluded by a different exclusion which relates to financial failures. So it's a really good example of how the sort of changing nature of the detention plays out.
Yes, yeah, and so. Just to complete that bit about trading regulations, then it won't apply if the regulations are in fact aimed at something other than the sale or importation of goods. So, for example, pollution, health and safety, any other type of regulatory measure. So finally then, as Ben just mentioned, in the Elisa Glacial, the Ishord went on to talk about how there's another exclusion that applied. But all I really want to say about that is it's very wide wording, any financial clause, but it's not wide enough to encapsulate everything. And in fact, the judge in that case observed that if you had a situation where a vessel was detained by terrorists, they said they would release it upon payment of a ransom and the insurer refused to pay. That would not be a detention which has arisen by reason of any financial clause, and that exclusion would not apply. So just to recap, what we've looked at so far is the way in which historically cover was provided for these type of war perils, and then excluded by the FCNS clause. We've then looked at how the Institute clause wording excludes war perils, and then the war and strikes cover adds them back in. And what we specifically zoomed in on are the exclusions from the war risk perils that give you an idea of what type of detentions might be covered or not under the war risk policy. But are there any detentions that might be covered under the main marine insurance policy? Well, you'll remember when we looked at the wording that there were some things excluded from the exclusion, including barratry and piracy. And it seems to me that this may give rise to detentions which are arguably covered under the standard marine insurance policy wording. And one example might be barratry smuggling, for example. And in fact, in the B Atlantic, Lord Mance left that point open. He said, assuming without having to decide that the effects of that subclause is that detainment following a barratry smuggling attempt is covered by the marine insurance policy. So there is at least an interesting point that could be argued there. And then secondly, I think that you may be able to argue that there is cover under the standard policy where the proximate cause is a covered peril, not in fact the detention, but the detention arises afterwards. So for example, the detainment following an explosion or collision, where the insured might argue that the proximate cause was the covered peril. But just a word of warning there in that case, note that where you have two causes of approximately equal efficiency and one is excluded, there will be no cover. And reasonably familiar case of Wayne Tank and Pump Co. and employers' liability insurance is authority for that principle. So just finally then, a couple of points of procedure on service of a notice of abandonment. As Ben mentioned, a notice required by section 62(1) of the 1906 Act. And just a couple of points of caution for the insured. The notice must convey an intention to abandon unconditionally. And so the insured should not do anything which could be construed as contrary to that intention. For example, care should be taken if continuing to crew, manage, or operate the vessel. And as Ben has mentioned, this is frequently dealt with by a RIC clause, an agreement with the insurer, just to set out what is actually going to happen with the practicalities of operating the vessel from that point onwards. And it may be necessary to reach an agreement with the insurer that the insurer continue to operate the vessel for the benefit and order of insurers without prejudice to its claim for constructive total loss. And from the insurer's point of view, just to caution that if you were to accept the notice of abandonment, that would constitute admittance of liability by reason of section 62(6), and that it is possible to waive the requirement for notice and the application of ordinary principles, and that one ought to take care to not do that. Okay, so that's the end of my section. I'd like to pass back to Ben to conclude.
Thank you, Will. Yes, well, so I want to leave enough time for any questions that you guys have, and we've taken up quite a bit of your time. So I'll just very briefly make the point that that there are lots of different, obviously, insurable interests and financial interests one can insure in relation to a vessel, which can be engaged by detention claims, and I've listed some of those there. One that comes up time and time again in the cases is mortgagee's interest insurance, which ensures that the interest of a lending bank in respect of a vessel. The reason why that comes up is because MII sort of basically provides cover in circumstances where the underlying hull and machinery cover has failed for some reason. And often in detention cases, the thing that makes the vessel be detained is also makes the hull and machinery cover fail. So an example of this is the Zuzu, where the vessel was trading in additional war risk premium areas, and that's not declared to the hull and machinery underwriters. And as a result, the H&M cover fails, and also causes the vessel to be detained in Venezuela. So you often get MII claims in relation to detention, and they're not straightforward. You have to. It's in some ways too much of a topic to cover in a very short space of time. But one of the difficult issues is always in showing a loss and what loss means in the context of MII insurance. So in the Zuzu, we had this sort of slightly awkward case where it was necessary to show a CTL under the owner's policy. But of course, the owner's policy had been avoided, so it didn't exist anymore. And a notice of abandonment had been tendered by the owners to their hull and machinery insurers on a particular date. So that date was said to be the relevant date for assessing whether the vessel was a CTL or not. But then you have a sort of complexity that notice of abandonment is in respect of a completely different insurance policy, and an insurance policy that doesn't exist anymore because it's been avoided. So, as I say, I mean, I think it's probably too much to deal with in the short time that we've got left. But I just thought I'd flag that up as being an interesting area that comes up from time to time. Now, the fourth and most important question: which barrister to instruct? I've given you a choice of two, but as Will pointed out to me earlier, we can work as a pair as well. So, thank you for coming.